Please put your thing on the Wi-Fi hotspot so I can connect.
Judges are here. Take this one. Just put it there. Is everyone ready? All rise. Judgment in the matter between the Democratic Alliance, this is the Acting National Director of Public Prosecution, and two others. Case number 19577 of 2009.
Please report on behalf of the applicant. On behalf of the amicus curiae.
May it please the court, my lord, I appear on behalf of the third respondent.
May it please the court, I appear on behalf of the first and second respondents.
Yes. Thank you. This is the judgment of the court, meaning that it has been prepared by us. We have decided to read it out because we realize that the public has got an interest in it. So we are not going to just read the orders. And the judgment is as follows. Introduction. This is a review application launched on the 7th April 2004 by the Democratic Alliance, DA, the official political opposition party in the Republic of South Africa. The DA asks this court to grant the following relief. Quote, reviewing, correcting, and setting aside the decision of the first respondent taken on or about the 6th of April 2009 to discontinue the criminal prosecution of Mr. Zuma in accordance with charges contained in an indictment of 27 December 2007. Declaring that the decision of the first respondent referred to in paragraph 2 above to be inconsistent with the Constitution of the Republic of South Africa of 1966 and invalid. The appropriate order of cost is also sought. The respondents in opposing this application are as follows. The first respondent is the Acting National Director of Public Prosecutions, ANDPP, who was at the time Advocate Mukotedi Mche SC, Mr. Mche. The second respondent is the head of the Directorate of Special Operations, DSO, namely Advocate Leonard McCarthy, Mr. McCarthy. At the time when this application was launched, the DSO was still operational. It has since been disbanded. The third respondent is Mr. Jacob Gedleyihlekisa Zuma, Mr. Zuma, the current President of the Republic of South Africa. At the time this application was instituted, Mr. Zuma was not yet the President of the Republic of South Africa. In addition to the respondents, an entity known as the Society for the Protection of Our Constitution was admitted to the proceedings as amicus curiae by authority of the court order dated 18 September 2015. On or about 28th November 2007, a corporate decision to prosecute Mr. Zuma afresh was made by Mr. Mche, Mr. McCarthy, and the prosecution team. Previously, charges preferred by the then National Director of Prosecution, Advocate Pikoli, were struck from the roll by the KwaZulu-Natal Division of the High Court during September 2007. The decision to charge Mr. Zuma in November 2007 was coincidentally taken at a period when the African National Congress, ANC, was about to hold its National Electoral Conference scheduled for 16 to 20 December 2017 at Polokwane. 2007, sorry. A president of the ANC was to be elected at the said conference. The main contestants for presidency were Mr. Zuma and the former President Mbeki. The timing of the service of the indictment on Mr. Zuma became an issue. The prosecution team, in particular Mr. Downer, wanted same to be served immediately, regardless of the pending ANC conference. The view of Mr. Mche was that service should be effected in early 2008 after the Polokwane conference was held, so as not to present an appearance of political interference by the NPA in influencing the outcome of the leadership contest. Mr. McCarthy's view changed and he wanted service to be delayed until after the conference. The respondents' main reason for opposing this application is that Mr. McCarthy unduly influenced and interfered with the service of the indictment for political reasons. On the 1st of April 2009, Mr. Mche took a decision to discontinue the prosecution against Mr. Zuma and announced it publicly on the 6th of April 2009. The said decision to discontinue the prosecution triggered this application. It took almost 7 years since this review application was launched for it to be heard by this court. The reason for the delay is, amongst others, that there were two main interlocutory applications which emanated from this review application following each other. We briefly referred to the said applications. The first interlocutory application concerned a challenge that was raised by ANDPP and Mr. Zuma in the Gauteng High Court Division, Pretoria, before Judge Renshot. The ANDPP and Mr. Zuma contended that the DA did not have locus standi to bring this review application, raised the reviewability of the decision of Mr. Mche and the question whether the ANDPP was compelled to furnish the record of his decision to the DA. The decision of Judge Renshot granting the order in favor of the ANDPP and Mr. Zuma was reversed on appeal by the Supreme Court of Appeal, SCA, in the matter of DA and others versus Acting National Director of Public Prosecutions and others. In the matter of Democratic Alliance versus Acting National Director of Public Prosecutions and others, which came before Judge Matopo in the Gauteng Division, Pretoria, the court had to determine whether the transcript of the conversations as recorded in the tapes should be disclosed in terms of Rule 53 of the Rules of the High Court. The SCA upheld the judgment of Judge Matopo that the transcript of the recordings should be disclosed and further ordered that the transcript of the recordings be redacted in order to protect the confidentiality concerning the representations made by Mr. Zuma to the ANDPP. Now dealing with the background. The decision to charge and prosecute Mr. Zuma was preceded by a protracted investigation that started in 2001. Mr. Mche was appointed as the ANDPP on 29 September 2007 after Mr. Piccoli had been suspended. The prosecution team investigating the case of Mr. Zuma consisted of Advocate Downer SC, Advocate A. Steinbeck, Advocate George Baloyi, and Advocate Deploy. The team and Mr. McCarthy were also advised by two private senior counsel, namely Advocate Ving Trengove, SC, and Advocate Breitenbach, SC. From November 2007, Mr. McCarthy kept Mr. Mche and his deputies in the NPA updated about the investigation of the matter of Mr. Zuma. In preparation to finalize the charges, the application for centralization of charges in terms of Section 111 of the Criminal Procedure Act 51 of 1977 was submitted to Mr. Mche on the 20th of November 2007. The prosecution team briefed Mr. Mche and deputies on 29th November 2007, and the decision to prosecute was finally approved. It is common cause that the decision to prosecute Mr. Zuma afresh was a corporate decision at the time. In the beginning of December 2007, a report in terms of Section 33 of the National Prosecution Authority Act 32 of 1988 was submitted to Minister Mabanda, the then Minister of Justice and Constitutional Development. Mr. Mche and the Minister had a conversation on the 4th of December 2007, where it is stated that the Minister raised concern regarding the safety and stability of the country should the indictment be served before the Polokwane Conference. On the 5th of December 2007, a day after the meeting with the Minister, Mr. Mche informed Mr. Downer that the service of the indictment would be delayed until January 2008. The indictment was served on the 28th of December 2007 on Mr. Zuma. In June 2008, Mr. Zuma launched an application in terms of Section 179 of the Constitution of the Republic of South Africa in the KwaZulu-Natal Provincial Division of the High Court for a review of the decision taken to prosecute him. On the 12th of December 2008, Judge Nicholson ruled in favor of Mr. Zuma. The ANDPP challenged Judge Nicholson's judgment on appeal in the SCA. On the 12th of January 2009, the SCA overturned Judge Nicholson's judgment. On the 10th of February 2009, the NPA received written representations from the legal representatives of Mr. Zuma. These representations were made on behalf of Mr. Zuma, but Mr. Zuma did not confirm the representations under oath. We pause to mention that the national and provincial elections were scheduled to take place on the 22nd of March 2009, and the inauguration of the President of the Republic of South Africa would take place on the 9th of May 2009. On the 20th of February 2009, Mr. Zuma's legal representatives made further oral representations to Mr. Mche and his deputies, as well as Mr. Ngwengwe. According to Mr. Zinyati's notes forming part of the record of the proceedings, the Browns Mall matter was discussed at this meeting. The Browns Mall report was released in November 2007 by the Joint Standing Committee. The report revealed an unofficial attempt to besmirch the person and integrity of Mr. Zuma. Mr. McCarthy was implicated in the compiling of the report and was openly criticized by the committee, which recommended that action be taken against him. No action was taken against Mr. McCarthy. On the 3rd of March 2009, the prosecution team considered the representations made by Mr. Zuma's legal representatives and submitted a memorandum to Mr. Mche dealing with both the written and oral representations, giving detailed reasons for the rejection of these representations. A material suggestion at the time was that the oral representations should be reduced to writing in an affidavit. This never took place. During the 6th to the 16th of March 2009, Mr. Zuma's legal representatives allowed Mr. Mzinyati and Mr. Hofmeyer to listen to the tapes of the intercepted telephone and SMS conversations between Mr. McCarthy and Mr. Mnuka, as well as between Mr. McCarthy and the Minister Mabanda, and between Mr. McCarthy and various other parties. In the meeting held on the 18th of March 2009, where Mr. Mche was also present, the NPA management informed the prosecution team of the contents of the oral representations by Mr. Zuma's legal representatives and came to the conclusion that they had a good case to be pursued against Mr. Zuma. There are two letters prepared in March 2009 in consideration of the representations and in which a response is prepared to Mr. Zuma's attorneys by the prosecution team and Mr. Mche. These letters form part of the record of proceedings. Annex D18 is a draft that was sent to Advocate Trengove SC to settle, and Annex D7 is a letter settled that was to be sent to Mr. Hali in response to the written oral representations. It is not clear if the response was delivered to Mr. Hali. The DA became aware of the legal representatives of Mr. Zuma and made representations to the NPA concerning the pending prosecution. They also requested to make representations. On the 20th of March 2009, Mr. Mche informed the DA as follows, I quote, "You are most welcome to make written representations to me. I must, however, request that it reaches me on or before the 27th of March 2009, as this is the date I have set for myself to apply my mind to all the information supplied and still to be supplied. You will appreciate that due to the wide publicity in the matter, it is in the interest of all concerned that I consider the representations as speedily as possible," unquote. On the same date, and after the prosecution team had received Advocate Trengove SC's opinion and or advice, they informed Mr. Mche of the essence of it. The gist of the information submitted to Mr. Mche is recorded as follows, I quote, "He advised against acceding to the representations. The proper forum for evaluating the allegations and their relevance to fair trial was the court. As envisaged in the permanent stay arrangements that we had already settled with the defense and the judge president," unquote. On the 23rd of March 2009, Mr. Mche informed the DA that he was not at liberty to adhere to their request to have insight into Mr. Zuma's representations and the representations he had made confidentially and without prejudice. On 30 March 2009, a meeting took place between Mr. Mche, his deputies, Mr. Ngwenwe, and the prosecution team. According to Mr. Mzinyati's notes, which were recorded at the meeting, Mr. Mche indicated that on 1st April 2009, he would make his decision. Mr. Mshe did not indicate as to the reason for making a decision on the 1st of April 2009. Mr. Mshe said he was satisfied that they had a strong case on the merits of the case. Mr. Mshe, his deputies, and the prosecution team had no doubt that the prosecution would proceed. Importantly, at that stage, Mr. Mshe had been informed of the contents of the intercepted messages between Mr. Mnuga and Mr. McCarthy. On 30th March 2009, Mr. Mshe addressed a letter to Mr. McCarthy informing him about the audio recordings regarding the contents of the tapes. Mr. McCarthy replied on 31st March 2009 requesting more information regarding the intercepted communications so that he could deal with the allegations against him. At the time, Mr. Mshe had indicated to the deputies that he wanted Mr. McCarthy and Mr. Nuga's responses to the tapes before making a decision. Prior to 31st March 2009, Mr. Mshe had been reluctant to listen to the tapes. This is stated in the ANDPP's answering affidavit, deposed to by Mr. Hofmeyer and confirmed by Mr. Mshe. On 31st March 2009, the deputies and Mr. Mshe personally listened to the tapes in the evening. This after Mr. Hofmeyer and Mr. Mzinyati had previously reported to Mr. Mshe and informed him of his deputies as to the contents of the tapes. On 1st April 2009, the following day, Mr. Mshe met with his deputies and informed them that he had been disturbed by what he had heard on the tapes. He had decided to discontinue the prosecution. The record of the proceedings reflect that Mr. Downer recorded on 2nd April 2009 that Mr. Hofmeyer was of the view that the prosecution should be stopped. But both the prosecution team and the other deputies were of the view that the prosecution should continue. It is clear from the memorandum that on the 2nd April 2009, the prosecution team had not been informed of the decision already taken to discontinue the prosecution. On the 3rd of April 2009, Mr. Downer was still of the same opinion but unaware of the decision already made by Mr. Mshe on the 1st of April 2009. He opined as follows, I quote, the recommendations should be declined along the lines of our draft letter to Mr. Hadi, which has now been considered, unquote. Mr. Downer further set out the two questions as advised by Advocate Trengo, SC, the legal advisor to the prosecution team. These are, I quote, can I say that my decision to prosecute was not improperly influenced by Advocate McCarthy's improper motives? A simple sine qua non test can be applied here. And if not, am I now still satisfied with ex post facto knowledge of Advocate McCarthy's shenanigans that the decision was on the merits the correct one, unquote. On 6 April 2009, Mr. Mshe met with the prosecution team led by Mr. Downer to inform them of the decision he had made to discontinue the prosecution. He later publicly announced the decision taken on 1st April 2009 to discontinue the criminal prosecution, stating his reasons in the press release. Mr. Downer, the leader of the prosecution team, records later in the memorandum dated 9 April 2009 as follows, I quote, "The legal aspects of the motivation were not given to us for comment beforehand. In the few minutes before the press conference, it was impossible to digest and comment on the legal justification given for the decision, nor was there the opportunity utilized to run this reasoning past two counsel who were available and eminently qualified to advise on these issues," unquote. On the 7th of April 2009, the DA launched the present application. On 8 April 2009, the charges against Mr. Zuma and team were formally withdrawn by the KwaZulu-Natal Division of the High Court. I now give with reasons for Mr. Mche's decision of the 1st of April 2009. The reasons to disclose the prosecution, the reasons to discontinue the prosecution against Mr. Zuma was stated by Mr. Mche in an address to the media on 6 April 2009. In essence, Mr. McCarthy, Mr. Nguka, and others are alleged to have manipulated the timing of the envisaged service of the indictment on Mr. Zuma against the latter for political reasons. The service of the indictment was supposed to be used to disadvantage Mr. Zuma in his contest against Mr. Mbeki for the presidency of the ANC. In announcing his decision to discontinue the prosecution, Mr. Mche stated thus, I quote, "All members of the senior management and the prosecution team participated in this discussion, and ultimately I take full responsibility for the decision I made," unquote. He further said, I quote, "The representations submitted by the legal representatives pertain to the following issues: the substantive merits, the fair trial defenses, the practical implications and considerations of continued prosecution, the policy aspects militating against prosecution. I need to state upfront that we would not find anything with regard to the first three grounds that militate against a continuation of the prosecution," unquote. Mr. Mche continued to state as follows, I quote, "In the present matter, the conduct consists of the timing of the charging of the accused. Even if the prosecution itself is conducted by the prosecution team is not tainted, the fact that Mr. McCarthy, who was head of the DSO and was in charge of the matter at all times and managed it almost on a daily basis, manipulated the legal process for purposes outside the extraneous to the prosecution itself. It is not so much the prosecution itself that is tainted, but the legal process itself. Mr. McCarthy used the legal process for the purpose other than that which the process was designed to serve. That is, for collateral and illicit purposes. It does not matter that the team acted properly, honestly, fairly, and justly throughout. Mr. McCarthy's conduct amounts to a serious abuse of process and offends one's sense of justice." Mr. Mche concludes as follows, I quote, "In the light of the above, I have come to the difficult conclusion that it is neither possible nor desirable for the NPA to continue with the prosecution of Mr. Zuma," unquote. Of importance, he also stated that, I quote, "Let me also state for the record that the prosecution team itself has recommended that the prosecution should continue even if the allegations are true, and that it should be left to a court of law to decide whether to stop the prosecution, unquote. There are thus three important decisions at the center of this review, namely, the first decision was that of the NPA and DSO to prosecute Mr. Zuma. This decision was taken on about the 28th of November 2007. The second decision of 6 December 2007 concerns the timing of the service of the indictment on Mr. Zuma. This is the decision which concerns the alleged misconduct by Mr. McCarthy. The question raised clearly are who took the decision, when, and why. And the third decision of 1st April 2009 is the one made by Mr. Mche to discontinue the prosecution of Mr. Zuma. According to Mr. Mche, the reason for this decision emanates from the alleged misconduct of Mr. McCarthy as stated above. It is this decision that is the subject of this review. The main reason for the 1st April 2009 decision to discontinue the prosecution is captured succinctly on the bottom of page 4 and the top of page 5 of Mr. Mche's statement, when he opines as follows about how the abuse of process may occur on its own. I quote, "It will not be possible to give the accused a fair trial, or it will offend one's sense of justice, integrity, and propriety to continue with the trial of the accused in the particular case. Discontinuation is not a disciplinary process undertaken in order to express one's disapproval of abuse of process. It is an expression of one's sense of justice and propriety." In brackets, see Connolly versus DPP 1964 AC 1254, close bracket, unquote. It is against this background that the court now tends to deal with the grounds of review of Mr. Mche's decision to discontinue the prosecution of Mr. Zuma. I now deal with the DA's grounds of review. When this review application was launched on the 17th of April 2009, the grounds of review supporting the relief sought were initially based on the provision of Section 6 of the Promotion of Administrative Justice Act, PAJA, in line with the decision of Battlestar Fishing Pty Ltd versus Minister of Environmental Affairs and Tourism and others. The reviewability of a decision to discontinue a prosecution was considered and dealt with by NAFSA JA in the matter of DA versus Acting and DPP and another. After considering the question, the SCA concluded that a review of the decision to discontinue prosecution can be reviewable on the grounds of legality and irrationality. This view was further endorsed in the matter of the NDPP versus Freedom Under Law, where the court stated in paragraph 29 as follows, I quote, "As demonstrated by the numerous cases since decided on the basis of legality principle, the principle acts as a safety net to give the court some degree of control over action that does not qualify as administrative under PAJA, but nonetheless involves the exercise of public power. Currently, it provides a more limited basis of review than PAJA. Why I say currently imposed is because it is accepted that legality is an evolving concept in our jurisprudence. This full creative potential will be developed in the context-driven and incremental manner. But for the present purposes, it can be accepted with confidence that it includes review on grounds of irrationality and on the basis that the decision maker did not act in accordance with the empowering statute. Open bracket, see Democratic Alliance and another. This is Acting National Director of Public Prosecutions and others, 2012, Volume 3, SA 486, SCA at paragraphs 28 and 30. I now deal with rationality as a ground of review. In paragraph 22 of its judgment, I'll repeat, in paragraph 32 of the judgment of the Constitutional Court in Albert versus Center for the Study of Violence and Reconciliation and others, explains rationality review as being really concerned with the evaluation of a relationship between means and ends. The relationship connecting or linking between the means employed to achieve a particular purpose on the one hand and the purpose or end itself. In paragraph 51, the Constitutional Court held thus, I quote, "But where the decision is challenged on the grounds of rationality, courts are obliged to examine the means selected to determine whether they are rationally related to the objective sought to be achieved. What must be stressed is that the purpose of the inquiry is determined not whether there are other means that could have been used, but whether the means selected are rationally related to the objective sought to be achieved. And if, objectively speaking, they are not, they fall short of the standard demanded by the Constitution," unquote. Rationality involves substantive and procedural issues. It follows, therefore, that both the process by which the decision is made, the means, and the decision itself must be rationally related. This principle was confirmed by the Constitutional Court in DA versus President of the Republic of South Africa. In the matter of freedom under law versus National Director of Public Prosecutions and others, Judge Murphy dealt with the question of review grounds under PAJA of a decision to prosecute. This matter went on appeal to the SCA, where the court held that the decision to discontinue a prosecution or not to prosecute can be reviewable not under PAJA, but on the basis of the principle of legality and irrationality. Importantly, further, that in deference to the doctrine in separation of powers, it is not appropriate for a court seized with a review application and upon setting aside the decision to step into the shoes of the prosecution and grant orders and directives as to how the prosecution should be carried out from that point onwards. The DA subsequently amended its grounds of review based on PAJA and narrowed them to the grounds of irrationality and legality in line with the authorities cited above. The applicant and respondents' counsel, by agreement, mainly based their arguments on the ground of irrationality. The parties did not present arguments relating to the declaratory relief sought by the applicant that the decision of Mr. Mche was unconstitutional. I now deal with respondents' contentions. It was argued on behalf of the first and second respondents, the ANDPP and DSO, in essence, that having regard to Brown's small report criticizing Mr. McCarthy's conduct of leaking information to the media and the contents of the transcript, Mr. Mche was justified in deciding to discontinue the prosecution of Mr. Zuma and that his decision was rational. Mr. Zuma's counsel argued that even if the merits of state's case were strong, the decision to discontinue was rational and justified because, according to the contents of the recorded conversations, the NPA's independence would be affected and it would be seen to be meddling with political decisions. Counsel further submitted that the fact that the plan of Mr. McCarthy to negatively influence the election of Mr. Zuma as president of the ANC was unsuccessful was immaterial. The abuse by Mr. McCarthy was of such a serious nature that the decision not to prosecute was rational. In our view, the alleged conduct of Mr. McCarthy, as appears from the transcript of the recorded conversations, if proven, constitutes a serious breach of law and prosecutorial policy. It is not even necessary to refer to his role in the Brown's Mall report, for which it seems he was not admonished. His conduct, as alleged in the transcript, again, as if proven, certainly calls for intervention. This will involve an inquiry into allegations and, if need be, also censure by a court of law. On being informed by Mr. Hofmeyer and Mr. Mzinyati about the content of recordings, Mr. Mche surprisingly did not immediately confront Mr. McCarthy and his predecessor, Mr. Nuka, about the allegations. He only did that on the 30th of March, 2 days before he took the decision to discontinue the prosecution. Both officials, who were no longer in the employ of the prosecution authority, requested access to the content of the tape recordings before they could comment. This was a reasonable request. Mr. Mche, however, felt it unnecessary to wait for their response and proceeded to make a decision on the 1st of April 2009. He thus made a half-hearted attempt at investigating and verifying the allegations before he took a decision. He had thus reached the cardinal rule of audi alteram partem, that is, hearing the other side before making an intervention. Mr. Mche, in his media address, concedes that the substantive merits and the fair trial defenses of the prosecution of Mr. Zuma were not tainted by the alleged conduct of Mr. McCarthy. However, the form of censure Mr. Mche chose by discontinuing the prosecution failed to demonstrate a connection or linkage to the alleged conduct of Mr. McCarthy. That is the essence of this review. The submissions of Respondents' Counsel have similarly, in our view, not addressed the question of this required connection or linkage necessary to determine if the decision meets the test of rationality. The amicus curiae argued that the DA should have brought the review application in terms of the provision of FAJA and that bringing the application in terms of irrationality is unconstitutional. It was further argued that the decision to prosecute or not to prosecute is by law taken by the Deputy Director of Public Prosecutions, not the National Director of Public Prosecutions. Therefore, it argues Mr. Mche could not have had the authority to take the decision as alleged. The submissions of the amicus curiae are clearly way off the mark and not supported by any decided cases. Writing for the SCA in the matter of NDPP versus Zuma, Supra, Harms, DP explained the powers of the NDPP in reviewing a decision to prosecute in paragraphs 70, 71, and 75 thus, I quote, I therefore conclude that section 179 bracket 5 bracket D does not apply to reconsideration by the NDPP of his own earlier decisions, but is limited to a review of a decision made by a DPP or some other prosecutor for whom a DPP is responsible. The head of the DSO is a post-constitution creation and is not a DPP but a deputy NDPP in terms of the NPA Act. You see section 7 bracket 3. Further, the fact that he joined in the decision making does not mean that the decision is no longer that of the NDPP. If the argument were correct, it would mean that the Mche decision was also not one made by the NDPP and would fall beyond the provision and destroy the basis of Mr. Kemp's whole argument because it too was made jointly with the head of the DSO. In addition, as held by the Constitutional Court, as soon as the matter had been struck from the roll by Mr. Msimang J., the criminal proceedings were terminated and the proceedings were no longer pending. Removal of a matter from the roll aborts the trial proceedings. The effect of this is that what went before Mr. Mche's decision was spent and a new decision to prosecute was required. The Mche decision was not simply a review of Mr. Nguga's decision, which was no longer extant. On these facts, section 1795, bracket 5, bracket D, had irrespective of whichever interpretation is correct, no application, and Mr. Zuma's reliance on it was misplaced, unquote. In regard to the submission that the DA should have brought the application for review in terms of PAJA as submitted by Mr. Omar, we refer to the decision of DA versus Acting NDPP Supra and the NDPP versus Freedom under Law Supra, where the two judgments deal extensively with the ground of review of a prosecution under PAJA and in terms of the principle of constitutional legality. It needs to be mentioned that the amicus curiae disappointingly failed to add any value to these proceedings. I now deal with rationality of the decision and abuse of process. The NDPP derives her authority from Section 9 of the Constitution of the Republic of South Africa, Act of 1996, which, I'll repeat, the NDPP derives her authority from Section 179 of the Constitution of South Africa, read with the national legislation enacted in terms of Section 1797 being the NPA Act. More specifically, Section 22 thereof, which deals with the powers of the National Director as well as the regulations dealing with prosecutorial policy. The prohibited conduct of NPA officials, including offenses and penalties, are dealt with under Section 41. The National Director of Public Prosecutions is also empowered to issue policy directives which serve as a guide to prosecution. Part 2 of the Prosecution Policy Directives, dated 1st June 2014, deals with the Prosecution Authority, while Part 5 thereof deals with withdrawal of cases and stopping prosecutions. The NDPP and all officials of the prosecution are required to act within the confines of these legal instruments. One of the objectives of the legal framework is to protect and preserve the integrity of the prosecution authority and its processes. The objective sought to be achieved through the decision to discontinue the prosecution of Mr. Zuma was, in Mr. Mche's view, to protect the integrity of the NPA and its processes. Thus, the decision to discontinue the prosecution was, according to Mr. Mche, a response to the alleged abuse of power by Mr. McCarthy, when the latter allegedly manipulated the timing of the service of the indictment on Mr. Zuma as a tool to achieve a political advantage for President Mbeki prior to the election of the leadership of the ANC at Polokwane Conference. In the 12-page media address announcing his decision to discontinue the prosecution of Mr. Zuma, Mr. Mche relies on the abuse of process doctrine. The DA submits that the words used by Mr. Mche in his statement have a striking resemblance to those adopted by Seagrove J of the High Court of Hong Kong in the matter of HKSAR versus Lee Ming T. This decision was, however, overturned on appeal, where the appeal court stated as follows, I quote, "Although the question is debatable, the better view is that an abuse of process does not exist independently of and antecedently to the exercise of judicial discretion. The judicial decision that there is an abuse of process which requires the grant of a stay is itself the result of the exercise of judicial discretion. It is for the judge to weigh countervailing considerations of policy and justice, and then, in the exercise of the discretion, decide whether there is an abuse of process which requires a stay," unquote. In the same media address, Mr. Mche also referred to the British case of R versus Latif as authority for the application of the abuse of process doctrine. The court on page 360, paragraph H to J, and page 361, paragraphs D to E states thus, I quote, "If the court always refuses to stay such proceedings, the perception will be that the court condones criminal conduct and malpractice by law enforcement agencies. That would undermine public confidence in the criminal justice system and bring it into disrepute. On the other hand, if the court were always to stay proceedings in such cases, it would incur the reproach that it is failing to protect the public from serious crime. The witnesses of both extreme positions leaves only one principal solution. The court has a discretion. It has to perform a balancing exercise," unquote. On page 361, paragraphs D to E, the court said, I quote, "General guidance as to how the discretion should be exercised in particular circumstances will not be useful, but it is possible to say that in a case such as the present, the judge must weigh in the balance between public interest in ensuring that those that are charged with grave crimes should be tried and the competing public interest in not conveying the impression that the courts will adopt the approach that the end justifies any means, unquote. In making reference to this case, Mr. Mshe surprisingly omitted to mention that the courts in both HKSAR appeal and the Latif matters were of the view that the determination of the principles of abuse of process was an exercise for a court of law and not an extrajudicial pronouncement. Mr. Mshe disregarded, without giving reasons, the recommendation of the prosecution team that even if the allegations regarding Mr. McCarthy are true, the decision to stop the prosecution was to be made by a court of law. The court in Latif matter also mentioned, I'll repeat, the court in Latif matter also held that the application of the abuse of process involved a balancing of two imperatives. The one imperative is where the court does not act on misconduct and malpractice by law enforcement agencies, a failure to do so will raise an ear of the public. The second imperative is the instance where the trial is discontinued, such as in this case. In such an event, the criminal justice system as a whole, and not only the NPA, will incur the reproach that it is failing to protect the public from serious crime. Mr. Mshe disingenuously omitted to consider or deal with this second imperative in his media address. The manner in which the prosecution authority must approach an allegation of abuse of process doctrine was also dealt with by the SCA in the NDPP versus Zuma, where the court held us, I quote, "A prosecution is not wrongful merely because it is brought for an improper purpose. It will only be wrongful if, in addition, reasonable and probable grounds for prosecuting are absent, something not alleged by Mr. Zuma and which in any event can only be determined once criminal proceedings have been concluded," unquote. The court of law is the appropriate forum to deal with the abuse of process doctrine, not extrajudicial process. Prior to 1st April 2009, and after he was briefed about the contents of the tapes, Mr. Mshe subscribed to the view advocated by Mr. Downer and the prosecution team that the allegations raised in the tape and the representation by Mr. Zuma's legal team must be subjected to judicial process. If anything, to test the veracity thereof, he concedes in the press statement that the prosecution team held this view, but on 1st April 2009, he inexplicably and irrationally abandoned this view. In the March 2000 draft letter to Mr. Hali referred to Mr. Mshe, and the NPA official expressed the view that the matters raised in the representations made on behalf of Mr. Zuma must be dealt with by a court of law during the trial. It is interesting that Mr. Mshe decided to discontinue the prosecution, although in March 2009, Mr. Mshe and the prosecution team recorded the following, I quote, "I do not consider that this matter in itself will prevent our client from having," I repeat the quotation, "I do not consider that this matter in itself will prevent your client from having a fair trial. If your client believes I am wrong in this assessment, then he will have an opportunity to persuade the court in intended permanent stay application or during the criminal trial itself, unquote. In February 2009, the KwaZulu-Natal Division of the High Court issued an order by agreement between the parties that Mr. Zuma would file papers for a permanent stay prosecution on 18 May 2009. This meant that such an application had to be filed in about 6 weeks' time. Mr. Mche does not state why he could not wait for a further 6 weeks for the application for stay of prosecution to be filed so that the court could ultimately deal with it. The matter has a protracted history since 2007, and we do not understand why Mr. Mche wanted to finalize the matter within a month after receiving representations from Mr. Zuma's legal representatives. The legal authorities cited above, of which Mr. Mche should have been aware or so advised, do not support the decision taken by him in an instance such as this one under review, where the abuse of process doctrine is applied in an extrajudicial exercise of public power. When the prosecution against an accused is discontinued. In this instance, the basis of the alleged abuse of process rested on legally untested allegations which were unrelated to the trial process and the charges. It is thus our view that Mr. Mche, by not referring the complaint of abuse of process and the related allegations against Mr. McCarthy to court, rendered his decision irrational. In the answering affidavit by Mr. Hofmeyer, confirmed by Mr. Mche, it is stated that when he, Mr. Mche, admitted to having told Mr. Downer that the decision was his and no one else, he was deliberately withholding the version that he had been influenced by Mr. McCarthy to delay the service of the indictment. This particular version was not disclosed to Mr. Downer during the conversation on 6 December 2007. Correction, on 6 December 2005. Excuse me? The correct date is 5 December 2007. Mr. Mche, in his supplementary affidavit presented after the DA had delivered its replying affidavit, raised a new explanation when he stated under oath as follows, I quote, "McCarthy told me that it would be harmful to the NPA, particularly the DSO, which was under severe attack at the time, if Zuma was prosecuted before the Polokwane conference. He believed that if Mr. Zuma were to be charged before the Polokwane conference, it would destabilize the DSO and NPA and the country. I met the minister during the evening of 5 December 2007. I raised with her the issue that the announcement would possibly be delayed. It was clear to me that she agreed that the prosecution should be delayed. She was concerned that the NPA would be perceived as targeting Mr. Zuma ahead of the Polokwane conference. The following day, in bracket 6 December 2007, I telephoned Downer to inform him of the decision to delay the Zuma prosecution. I told Downer that I had taken the decision to postpone the prosecution independently. I told him that it was my decision and my decision alone. I did so because Downer was aware that I had met the minister the previous day. I did not want him to think that the minister had interfered or that the minister had unduly influenced me. I did not tell Downer that it was Mr. McCarthy who had persuaded me that it was necessary and that delaying the prosecution was a better option for the NPA. I knew that the decision to delay the prosecution was likely to be unpopular. I knew that Downer would be unhappy with that decision. As head of the NPA, I felt that I had to support the decision. McCarthy had already made the decision. I did not want to blame it on others when I knew it was likely to be unpopular. As expected, Downer was angry about the decision to postpone the prosecution, unquote. The paragraphs from Mr. Mche's supplementary affidavit, as quoted above, read with Mr. Hofmeyer's affidavit as to who took the decision to delay the service of the indictment and why, presents three contradictory versions. The first version is that Mr. Mche took the decision, which was his and his alone. The reason being in consideration of the speech by the then President Mbeki calling for calm ahead of the ANC election in Polokwane. The second version is that he took the decision after being influenced by Mr. McCarthy. He does not indicate when this alleged influence occurred and why he allowed himself to be influenced whilst knowing of Mr. McCarthy's participation in the Browse Mall matter since 2007. He further stated in a draft letter to be sent to Mr. Harley in March that he was not influenced by Mr. McCarthy. The decision the decision to not withdraw the charges was set out in this draft as follows, I quote, "After anxious consideration, I have concluded that my decision to indict your client in 2007 was not influenced improperly or otherwise by Advocate McCarthy. This is notwithstanding the fact that we both agreed on the decision. Even in the event that I'm wrong in this conclusion, having now again reconsidered the decision, even taking into account your representations, I remain convinced that it was and is the correct decision," unquote. This decision was the decision to prosecute. The third version is that it was Mr. McCarthy who took the decision and he, Mr. Mche, felt he had to support it. If this was indeed so, why did he have a difficulty in disclosing this unpopular decision that was not his to Mr. Downer, who at the time was reporting to Mr. McCarthy? It seems from the reading of the answering affidavits of Mr. Hofmeyer, confirmed by Mr. Mche on behalf of the NDPP and Mr. Harley on behalf of Mr. Zuma, that an attempt is made to attribute the decision to postpone the service of the indictment to Mr. McCarthy. Mr. Mche portrays himself first as a person who was in charge and independently took the decision. Secondly, that he was not persuaded by the minister, but he was influenced by Mr. McCarthy to delay the prosecution. And thirdly, that he, Mr. Mche, acted as an official who was supporting a decision made by Mr. McCarthy. It may well be that there is a plausible explanation for these contradictions. However, the consequence of failing to refer this matter to court, as it was agreed among the prosecution team, the NPA, and after so advised by Advocate Trengo, shows that Mr. Mche's decision is irrational. The DA submits, within the context of Mr. Mche appearing to disown the decision to delay the service of the indictment, that Mr. Mche lied when he failed to disclose the truth to Mr. Downer on 5 December 2007. It seems reasonable to infer that Mr. Mche was also persuaded by the discussion in the meeting with the minister on the evening of 4 December 2007, the day before he telephoned Mr. Downer. On his own version, he did not want Mr. Downer to form an impression that he was influenced by the minister, not Mr. McCarthy, as he now suggests in his supplementary affidavit. Significantly, he neither mentioned to Mr. Downer that Mr. McCarthy had influenced him, nor that the decision was made by Mr. McCarthy. If it was Mr. McCarthy's decision, nothing prevented Mr. Mche from stating this to Mr. Downer. The latter's anger or disappointment would then have been directed to Mr. McCarthy. Apart from the contradictory versions as to who took the decision to delay the service of the indictment and for what reason, there has been no attempt in the papers to explain how Mr. McCarthy's alleged influence and lobbying to have the service of the indictment delayed would have disadvantaged Mr. Zuma. It seems to us that it would be logical to assert the view that the service of the indictment before Polokwane Conference would have thwarted the ambitions of Mr. Zuma to assume the leadership of the ANC. However, it is not indicated in the papers before us how the service of the indictment after the Polokwane Conference, as allegedly advocated by Mr. McCarthy, would have been a tool to influence the outcome of the elections, which, as logic dictates, would by then have occurred. Indeed, it so happened that the indictment was served on Mr. Zuma after he had been elected president of the ANC. In an attempt to bolster this obvious irrational explanation, the NPA and Mr. Zuma brought into their answering affidavits the previous conduct of Mr. McCarthy in regard to his role in the Brown-Small report. The Brown-Small report did not relate to the timing of the service of the indictment, which in this instance is a high watermark of Mr. Mche's reason to discontinue the prosecution of Mr. Zuma. It only served to describe the character of Mr. McCarthy as an officer who is inclined to meddle in political affairs, nothing more. It was information well known to Mr. Mche even before he heard the tapes of recorded conversations. It is irrational to argue that it constitutes the basis upon which the prosecution was to be discontinued. Thus, the information on which Mr. Mche based his decision to discontinue the prosecution on Mr. Zuma is inconsistent with and does not support the allegation that by seeking to delay the indictment, Mr. McCarthy sought to influence the outcome of elections and therefore demonstrated an abuse of process. There is thus no rational link between the alleged misconduct of Mr. McCarthy and the decision of 1st April 2009. As already stated, the decision to discontinue the prosecution of Mr. Zuma was taken on the 1st of April 2009. It was announced to the public on the 6th of April 2009. The chronology of events stated earlier in this judgment indicates that at all material times and since the 27th of November 2007, the decision of Mr. Mche and senior members of management team of the NPA had been to continue with the prosecution. The prosecution team led by Mr. Downer also held this view even after Mr. Mche had unknowingly to the prosecution team taken the decision to discontinue the prosecution. Even after the legal representatives of Mr. Zuma had made representations to Mr. Mche and senior members of the management of the NPA during February 2009, the view was consistently held that the prosecution must continue. There is no record that there was a change of this view right up to the evening of the 31st of March 2009 when Mr. Mche and other senior members of the management team listened to the tapes. Mr. Hofmeyer records in his affidavit that he and Mr. Msinyati briefed Mr. Mche and other senior members of the NPA on the content of the tapes. Therefore, at the time when Mr. Mche decided to listen to the tape on 31st March 2009, he had been briefed about the content and knew what to expect. However, the following day, on the 1st April 2009, Mr. Mche announced to the NPA senior management that after listening to the tapes, he was angry and felt betrayed, and therefore have decided to discontinue prosecution. When Mr. Mche announced his decision on 1st April 2009, no discussion was held with senior members of the NPA to source their views on this subject. This omission is critical, considering that up to the 31st of March 2009, they have been collectively discussing and agreed to continue with prosecution. They too had been briefed on the content of the tape, and on the evening of the 31st of March 2009, they heard the tapes with Mr. Mche. It is expected that they individually would have formed some views on the matter. Failure to source their views under the circumstance was irrational. Mr. Mche did not reveal that he had heard new information on the tape, which was not stated to him previously by Mr. Hofmeyer and Mr. Mzinyati during their briefing, and which caused him to change his mind. There is no evidence that after he had listened to the tapes, there was something specifically that he had heard which was not brought to his attention during the briefing. The record reflects that he still had the view that the prosecution must continue, even after he was briefed on the content of the tapes. His sudden, inexplicable turnaround on this matter is clearly irrational. Mr. Mche referred to the pressure exerted on the NPA concerning the fate of the intended prosecution on Mr. Zuma. During argument, counsel for Mr. Zuma stated that his client needed a response from the NPA as he was due to be sworn in as the President of the Republic of South Africa within a few weeks. Mr. Mche was subjected to such pressure that he could not afford the time and space to properly apply his mind on the implication of what he was about to do. He failed to exercise and apply the balancing act of the two imperatives necessary for the consideration of the abuse of process doctrine. Mr. Mche ensured that the prosecution team and Mr. Downer were not informed of the decision until 6 April, when he was to announce it to the public. If indeed the decision had been rational, and above board, why the secrecy? Needless to state that Mr. Downer, unaware that the decision had been taken on 1st April 2009, the following day, on 2nd April 2009, submitted a comprehensive memo motivating why prosecution needed to continue. Mr. Mche did not allow or offer any opportunity to Mr. Mgwengwe, the Director of Public Prosecution in KwaZulu-Natal, who had authorized the indictment and thus the prosecution, to listen to the tapes and state his views. It was, after all, the indictment he had signed concerning a case he had authorized prosecution which was being discontinued. Mr. Mche failed to explain how the information he had heard on the tapes could be said to have affected, compromised, or tainted the envisaged trial process and the merits of the intended prosecution. In fact, in his media address, he concedes that the alleged conduct of McCarthy had not affected the merits of the charges against Mr. Zuma. There was thus no rational connection between the need to protect the integrity of the NPA and the decision to continue prosecution against Mr. Zuma. He totally ignored the concerns he had personally raised prior to making the decision that the information from the tape and the representations from Mr. Zuma's lawyers had to be investigated, verified, and tapes authenticated. Mr. Zuma, in his own brother Mr. Mche, in his own words, on 1st April stated that he felt angry and betrayed. It is our view that his feelings of anger and betrayal caused him to act impulsively and irrationally, considering the factors as stated in the preceding paragraphs. He did not allow himself to consider the question whether the very decision he was about to take could be regarded by other people facing similar charges throughout South Africa as a breach of the principle of equality before the law, or that it would be an abuse of process to discontinue charges against people of high profile or standing in the community. The NPA ignored its own views as set out in the draft letter that was to be sent to Mr. Hali, which conveyed the following. I quote, "The conflict between your client's defense and prosecution's evidence can only be determined if all the evidence the prosecution and your client wish to adduce is presented and tested in a court of law," unquote. For the reasons set out above, this court finds that there is no substance in the submissions of the respondents and the amicus curiae. Conclusion and finding. Having regard to the constructors of the evidence before us, we find that Mr. Mse found himself under pressure and he decided to discontinue the prosecution of Mr. Zuma and consequently made an irrational decision. Considering the situation in which he found himself, Mr. Mse ignored the importance of the oath of office, which demanded him to act independently and without fear and favor. It is thus our view that the envisaged prosecution against Mr. Zuma was not tainted by the allegations against Mr. McCarthy. Mr. Zuma should face the charges as outlined in the indictment. The respondents further argued that since the charges against Mr. Zuma were formally withdrawn on 8 April 2009 after Mr. Mche decided to discontinue the prosecution, the order sought in the notice of motion may be of no consequence. We are constrained to state that the said technical argument was not raised in the papers and it cannot render the order we are to make hearing inept and ineffective. This court, for reasons stated above, finds that the decision of 1st April 2009 by Mr. Mche to discontinue the prosecution of the case against Mr. Zuma is irrational and should be reviewed and set aside. I deal with the costs. The costs follow the result and the respondents to bear the cost of this application jointly and severally, the one paying the other to be absorbed. Concerning the amicus curiae, in exercising our judicial discretion, we think it would be appropriate we think it would not be appropriate to make a cost order against it because it was admitted by the court and the opposition to its application was withdrawn by the applicant. Furthermore, the applicant did not persist that a cost order should be made against the amicus curiae. In the premises, it is hereby ordered: 1. The application succeeds. 2. The decision of the first respondent dated 1st April 2009 to discontinue the prosecution of the case against the third respondent in accordance with the indictment served on him on the 28th December 2007 is reviewed and set aside. 3. The first, second, and third respondents are ordered jointly and severally to pay the cost of the applicant, including costs of 3 counsel. And 4, no cost order is made against the amicus curiae. This is the judgment of this court. Court adjourned.
All right.
So why don't you do it outside? I like to crowd yourself here.